Davia Brown.
I'm Brandon Lyles.
And I'm Stacy Loveland, and we're excited to have you join us for Colonial Williams.
Don't study law, Jefferson. Study men.
I do remember the last time I saw her. She was standing on an auction block.
We intend for independence.
He tells me that he wanted liberty and equality.
But fear within a city.
A free white Englishwoman.
Of course, Lord Cornwallis himself.
Friends, you have been a delight. It is always a pleasure.
The dignity and worth of human personality.
What does it mean when laws are unethical? Are you obligated to stand against them, even if it breaks the law? What does standing up look like? Would anyone fault you if you stood down? In the year 1770, 6 years before the colonies stood up in treason and declared independence, there was a case before the highest court in Virginia, the General Court. Most cases deal with land rights or acquisition, income, and inheritance. Only a few cases are truly landmark. This is one of those cases. The trial was between an enslaved man named Samuel Howell as plaintiff and Wade Netherland, the enslaver, on defense. The slave owner was represented by esteemed attorney and law teacher George Wythe. Samuel Howell was represented by Wythe's young student, Thomas Jefferson. Thomas Jefferson stood to present his opening remarks. Jefferson cited two main Virginia laws, one in 1705 that bound all mulattoes or people of mixed race into 31 years of slavery, and one 1723 law that also binds their children into 31 years of slavery. Jefferson reminded the highest court in Virginia that there was no law that would bind any third-generation mulatto into slavery. If Jefferson wins, all mulattoes, third generation and on, would be freed. Thousands of lives would be changed forever. The high court grew anxious. Jefferson smelled victory. Jefferson ended his opening remarks with a flourish, saying for the first time on record a phrase that Jefferson would use again in 6 years. Under the law of nature, all men are born free. Everyone comes into this world with a right to his own person. Sensing complete victory, Jefferson concluded that a judge would be wicked to protect a law that did not exist. Jefferson and Samuel Howell rested. Defense's turn. George Wythe rose to present defense opening remarks, and as Wythe rose, something was amiss. The court finds favor in defense. Howell lost. Status quo won. The case was over. The room was cleared. The next case brought in. The court protected a law that literally did not exist. Samuel Howell, in 6 words, had his life taken from him again. Seven years later, in 1777, 1 year after George Wythe signed the Declaration of Independence written by his student Thomas Jefferson, these two men are on a committee to investigate every word of every law in Virginia, including slave law. The committee is called the Revisals Committee. Now, with the monarchy gone, these two Virginians have the ability to help alter the same legal landscape that they represented back in 1770. They can help create laws to change the exact situation that put Samuel Howell into bondage in the first place. Will these men choose to place ethical values of natural rights into law, or will they succumb to the same fallible faults that the High Court did in 1770? Welcome to Law v. Ethics.
At a place unlike
anywhere in our history. And when I say our history, I mean the history of mankind. My friends, I believe that I am known to you already, but if I'm not, my name is George Wythe. I am here alongside my former apprentice, I'm pleased to say now friend and colleague, Mr. Thomas Jefferson. The two of us, having just last year been directly involved in the Continental Congress, Mr. Jefferson, of course, the primary author of the Declaration of Independence, a signer, and I myself, a signer the same, have returned here now in this year, 1777, to Virginia with the express purpose of sitting on a special committee. The committee is for the revisal of the laws of Virginia. And I say to you that we are in an unknown moment in man's history because we have the opportunity here and now, in this moment, to consider the laws of the place as a whole, the laws of our country in their entirety, to reform what ought to be reformed, to omit what ought to be omitted, and to create what we think ought to be created. That it might better reflect our modern society and our modern viewpoints. Our laws, as you know, are rooted deep in history. British common law itself is rooted in Roman law, all the way back to Justinian and before. And it is our hope on this committee, not only Mr. Jefferson and myself, but also Mr. Edmund Pendleton, who sits on it with us as well, that we might be able to better not only the lives of the freeholders here in Virginia, but all who dwell within its jurisdiction. Mr. J, you seem to have a little hesitancy, if you don't mind me saying.
Well, I believe my hesitancy comes from the same form by which we felt in, well, do you recall in 1770 in the trial Howe versus Netherland where you and I stood on prosecution and defense?
I do.
In that moment, though the law was on the side of prosecution, at the end, men chose an unlawful path, an illegal path, and indeed to stand against ethics. And I worry that though we stand now in this moment to create law in Virginia, my fear is that, that we will come up against the same problem that we came up against in 1770, status quo, tyranny of the majority, comfortability. This is the way it has always been. How do we get a man to vote on behalf of his neighbor, even if it is against his own self-interest, because it is the ethical thing to do? These bills that we are proposing, they might be right and good and true, but we must stand against man's inherent demons, and that is why I have some hesitancy at this moment.
I understand your hesitancy, sir. And I confess to you, we sit at a terrible crossroads, you might say. One that we are entirely familiar with, even within the last year, even within the business of the aforementioned passing of the Declaration of Independence, the adoption, rather, by the Congress. But here and now, we have the opportunity to take these two, oftentimes, opposing entities, the law and our ethics, our morals, virtues, our values, and better intertwine them, that they might be a better reflection of not only you and I, but of our country as a whole. And this is the question that is before us, and I doubt not the question that is heavily on your minds as you join us here today. We are also joined this afternoon by Dr. Joseph Ziarko, who is in the space here with us. Good afternoon, Dr. Ziarko.
Good afternoon. It's a pleasure and an honor to share this space with you two gentlemen. I'm here to help ask any questions that anybody viewing might wish to ask you, so I encourage anybody, if you have a question, please send it in the comments. But to begin, Mr. Jefferson, you mentioned something, and I hoped that you would expand on it ever so slightly, especially as you mentioned, Mr. Wythe, comes a year after we had declared ourselves independent, an act many would describe as treasonous. You mentioned earlier in reference to the previous case that ultimately an unlawful action was taken, which I was hoping you could expand on that and perhaps let us know, and if Mr. Wythe, you want to weigh in on this, do you personally advocate people breaking unethical laws?
Well, I thank you, Dr. Ziarko, for the curiosity. What is man to do when you stand under a society that you know to be unethical and yet lawful? We can speak of slavery, for example. The case that we were referencing and the case that you were referencing, Dr. Ziarko, is Howell v. Netherland. In the outcome of that case that you no doubt know, the court found favor in defense in the slave owner. This was, in my belief, unlawful and unethical. Now, in that moment, I do not wish to place further extremis on my client, Samuel Howell, but after the case, Mr. Howell took it upon himself to go against the law, to gain his own freedom, to run away. At that moment, he saw an illegal action taken by the state, an unlawful system of bondage placed upon his person, and upon his own system of personal ethics, found that his ethics superseded law, and he broke the law and fled. This is his choice, and if I might be so bold, I aided him in the effort, giving him some money in his flight. Mr. Wythe.
It is important, I think, for us to remember that the law and morality are two different things. It is our hope, our sincere hope, I think, as a people, as any man would say, that they should intersect very plainly. But our law is not necessarily based in morality. As we will sit here and now, all those who are joining us here this afternoon, I would wager that out of context of this place that we live, Virginia, any man would listen to the words of John Locke and say, "In nature man is born free," and all here would nod their heads in agreement. But the law here in Virginia does not point to that virtue. The law here in Virginia states that if you were born, as per the year 1662, if you were born to an enslaved mother, then you yourself are enslaved for life. And in this I think is the point at which we stand, Mr. Jefferson. In this point, we can hope, here and now, to better align these laws. We have this opportunity as a people, even outside of the bounds of this committee, is it not true? Living in now a democratic republic, wherein the voice of the people becomes the voice of the law. Vox populi, vox Dei. The voice of people is the voice of God. And in that, we might hope to create a system of laws where men do not find themselves bound by moral convictions outside of it, so long as those convictions are rooted in true virtue, meaning, as you wrote in the Declaration of Independence, rooted in the law of nature.
Gentlemen, I have two questions here from two different individuals, but I think they speak to something to each of you individually in their own way. Ezra, age 11, wants to know, Mr. Jefferson, how did you feel in 1770 when the court ruled against you? And McKenna from Orlando would like to know, Mr. Wythe, how did you feel about defending what sounds to be an inherently unlawful argument? Did you have any moral qualms doing so? Both of these individuals wanting to know how you felt with that ruling.
The first gentleman's name is Ezra, is that right?
Yes.
Ezra, it's not easy to lose. No man enjoys losing, but when you take on a case, you understand that losing is at least always a possibility, even though you might know that your side is right, and you might truly believe, having created and discovered precedent, that your client is in the right and that you should by all rights win. Now, what transpires with a court The court may indeed find favor in your opposition. In my case, that was in defense. How did I feel? In some ways, Ezra, it's a bit nugatory how I feel. I was not on trial. It wasn't my life that was being decided. It was Samuel Howell's. His 31 years of servitude was being decided. So while I may think it wrong, and I may find some discomfort in a court deciding a case in an illegal way, the truth is, I think that question is better suited for Mr. Samuel Howell, who stood in court and was right, and at that moment the court decided to protect a law that did not exist and thus remove years from his freedom. That's a travesty.
Thank you, Mr. Jefferson. McKenna, on my end of the argument, I confess it to you. By this time in my life, I had come to the conclusion that the institution of the keeping of human property here in Virginia was a blight on our society. But at the same time, I had a duty to uphold. You see, there are only about 10 or so men who are qualified to argue before the general court here in Virginia at any given time. And in addition to that, in the court system, in British society, and now in a free and independent Virginia, you have the right to representation, so long as you can afford the counsel. I was approached by Mr. Netherland, and because he has a right to representation, despite my personal feelings on the matter, I knew that it was my duty to represent him as well as I could. I don't mean to make it sound as if I was unfeeling towards Mr. Howell. In truth, in my mind, I thought that the court ought find in favor of him. After all, legally speaking, he was on the right side of the law. But we allowed, when I say we, I mean the court. The court allowed the convenience of keeping Mr. Howell in bondage for the remaining of his 31 years of servitude, to take the day, despite what the law said.
Thank you, gentlemen. April asks, would you define morality and ethics as the same, or are they different? And where do you believe morality should be based?
Thank you. What was the name, Mr. Ziarko?
April, I believe.
April. Thank you, April. This is an important question for us to ask. In plain nature, April, when we are speaking of morality and we are speaking of ethics, we are all pointing towards the same word. It's a word that we commonly utilize. A friend of ours who was once on this very same committee, as a matter of fact, utilizes this same word when penning out the 16 articles of the Virginia Declaration of Rights. The word to which I am speaking on is virtue. Our virtue is rooted in this natural law of which I spoke. Now, there are 4 main points to the law, and we don't have time to go through all 4 of them. But when people speak of the law, they most commonly are referring to the municipal law, the localized law. You might think the laws of Williamsburg, the laws of Virginia, even. But there are 3 laws that are commonly regarded as superior to that. And the most superior, the top of the ladder, the first and most enduring, was the one that is created by nature. These are the laws that philosophers look into, whether they be moral or natural. And in this virtue, we derive our morality. We derive our ethics. And so, in truth, though I don't think they are exactly the same thing, they point to the same beacon. And in this virtue, we see very plainly, even guided by Scripture. The psalmist tells us, the heavens proclaim his glory, the firmament showeth his handiwork. When men look into nature, they see these things. When Newton looked into nature, he saw that an object in motion remains in motion. An object at rest remains at rest. Every action has an equal and opposite reaction. When Locke looked into nature, he saw that in nature man is born free. He saw that men are fallible and cannot create perfect laws. So how is it that we create more perfect laws? We cannot create a perfect union. How is it that we create a more perfect union? It is by looking to virtue, by which we derive our morals, and our ethics.
Thank you, gentlemen. Jolene has a wonderful question here, and it is about how do both of you deal with the ethics of holding slaves? This is, of course, something that I'm certain is on the minds of the many as we have circled some phrases about men being free or equal, certainly in this last year. But both of you gentlemen, if I'm not mistaken, do own human beings as property. Is that correct?
Indeed, that is correct.
I'm certain either of you could then answer that how do you deal with the ethics of doing that?
What is the questioner's name again?
Jolene.
Jolene. It's not unusual for us to see hypocrisy in our age. I'm sure, Jolene, if you were to look around and truly think, and you might think even at this moment, of the laws of your age, of your society, and your philosophic beliefs, and you find, Jolene, that they exist with some dissonance between them. It might even be the case that your philosophic beliefs exist on that higher rung that Mr. Wythe was speaking of, and yet your law falls short of your philosophies, your system of ethics, your code, what is codified into creation of your character. The same exists in our time. We have slaves. I inherited my slaves, as do many men. The question is now, what do we do about it? There are many things that are said about me, Jolene, and I have no doubt that you have read them or have heard them. One thing I am not is stupid. I understand fully that there is a distinction, heavy distinction, between saying all men are created equal and yet owning slaves. You might not even know this, but at the time I was writing the Declaration of Independence, there was an enslaved man named Hemmings sitting at my elbow serving me tea while I was writing the phrase, all men are created equal. I understand this. The question is, what do we do about it? Where do we go from here? What is the action that is now taken out of this? We can inherit all sorts of faults from our country. But if we continue those faults, then we are to blame. If we discontinue them, then we are a part of the solution. So one of the moments that Mr. Wythe and I are looking at with the revisal of the laws in Virginia is doing away with slavery in Virginia, to actually say that all men are created equal and truly mean it. That's the hope. Now, at the end of the day, Jolene, you understand, this bill, let's call it Bill 51, this bill must be presented that will make the slave trade illegal in Virginia. This bill must be presented to a body of men in Virginia, all of whom own slaves. And then that bill must be debated by a body of men, all of whom own slaves, and then be voted upon by a body of men, all of whom own slaves. I hope that you are seeing the problem, Jolene. I mentioned it earlier. It has many names: status quo, tyranny of the majority, comfortability, self-interest. If you can solve self-interest, Jolene, you will not just solve slavery, you will solve every problem this country will ever face.
Thank you so much. That leads to a question that Tina asked, and maybe you've already circled it, but she wanted to beg the question of, shouldn't a lawmaking committee include people other than white, presumably slave-owning males? How else can you develop laws that are more unethical for all peoples?
You know, this is an interesting question to ask in this moment. I have heard, Mr. Jefferson, I think perhaps you've heard the same, that the new Constitution of New Jersey does not expressly forbid women, femme souls, women who have property, the franchise, the vote. This has been something that has been questioned time and time again. Our tradition, meaning common law tradition, does in fact require for you to have the franchise that you be free, white, male, property holding, and Protestant. In Virginia, Protestant simply means not Catholic. That being taken into consideration, there are many who would make the case, and I think rightfully so, that the definition of one's sex has very little to do with your capability, meaning your mental capacity. I know, speaking for myself, that Mrs. Wythe is my closest confidant, that there is no one that I take my questions to or whose counsel I seek first, other than her. I've heard it said many times, and I think it to be true, that no piece of legislation ever passes around a committee table before it's passed around the dinner table. And so if we are in consultation of our wives, or if we think that, this is just an example, femme souls are capable and desirous of the franchise, is this something that we ought to consider? Well, I should say this to you. Even if you do not have the franchise here in Virginia, you have the capability, you have the right, if you are a free person, to petition the government. You have the right to utilize the court systems. Under the old system, you had the right to petition the king. Under the new system, you have the right to petition the governor. If you believe you ought to have the franchise, even if you are not of the male sex, then you ought to petition the government for it. They are required, as the representatives of the people of Virginia, to hear you.
You know, I'm reminded, sir, that there might be citizens who are listening today, watching today, who might have the franchise. I know this will come as an astounding thought to us both, but perhaps you can imagine this franchise has expanded. If you enjoy rights in your time, if you enjoy the right of suffrage, for example, you didn't get there because you could vote. You got there, and you enjoy that right today precisely because men in power chose to vote on your behalf. Isn't that something? So if you now have this right of suffrage in your time, you should look to those who are being denied and demeaned and vote on their behalf, because you are the direct beneficiaries of men doing this for you.
Gentlemen, Laura asks a question about representation as well, but very specifically, she says, as the author of the Virginia Declaration of Rights, why wasn't George Mason included? She says in the program, but I imagine maybe on this committee.
Why wasn't George Mason included? He was on this committee of 5 men whose job it is to look at every law we have in Virginia and decide what should remain, what should be tossed, what should be altered, and what should be created anew. George Mason was a part of this committee. Unfortunately, some internal illness or sickness has pulled him away. He was, while he was on this committee, a valuable member, and we thank him for his work on this committee.
Very good. I was curious of that myself. Aaron asked a bit ago about you breaking the law. I think this maybe is involved with the fact that you both signed the Declaration of Independence, but it also begs a question for me of what happens if lawmakers break the law? I think either of you could answer it.
Yes, in terms of the Declaration of Independence itself, I think it's very important that we take a moment to consider that we moved in line with virtue as much as possible. Understand, and I know that you know this, Aaron, and I think all who are with us here are of the understanding that Mr. Jefferson did not wake up on the morning of the 2nd of July and decide that he would no longer be a member of the British Empire without any forethought being put into it. Nay, there were years, over a decade, of long suffering put forward into repairing the relationship between the colonies, the former colonies here in North America, and the mother country. To return to Locke, he says very plainly that no government will be able to subsist if people set up a new government every time they take offense at the old. And even the Declaration itself makes note that people will stand long-suffering in government so long as those evils are sufferable. So it is important to know that so far as the Declaration of Independence and the independence of these now United States is concerned, it was kept in line with the notion that we did not wish to simply willy-nilly throw off the yoke of the British government, It was after the British government became a British tyranny. And we considered ourselves, at least I'll speak for Virginia, we considered ourselves to be so rooted in British blood that we knew in order to maintain our British rights, it was necessary that we be British no longer.
Thank you, Mr. Wythe. Samantha here has a question for you. How can or how should each branch of the government balance laws and morals? Should the executive branch enforce laws selectively to adhere to morals? What role might the other two branches of government play? But I think this is a fascinating question for you. Dealt with morality and the law on the side of the judiciary, but of course we must consider it at all aspects, and you're now experiencing it as legislatures creating the law. Could one or both of you gentlemen speak to this?
Samantha?
Yes.
I thank you, Samantha. This is a rather prescient question. We understand as men are flawed that our government will necessarily be flawed, and thus including our system of laws and the very system of government itself. So if government is to check, if the creation of government is to check man's flaws, to be a system of checks upon man, then who checks government? This actually passes quite nicely from the last question, which dealt with lawmakers breaking the law. No one is ideally in this new republic above the law. If we do have one man who is above the law, then we exist under a monarchy and no longer a republic that utilizes democracy. One of the ways in which we might check a man's inherent bias and inherent flaws is to allow one tripartite, this government is in a tripartite system, to allow one portion of this government to pass through a system of checks from another portion. We might think, for example, for the judiciary. In the judiciary, in the case that you saw, unfortunately that judiciary protected a law that was not created by the legislative. It might work in the reverse, and I can see this happening, that before laws might be passed, or before bills might rather be passed into law, might it pass some judiciary check to check a constitutionality of such a law? This might indeed be beneficial. Now, we're speaking a bit forward in time. We don't yet have the federal government or a federal judiciary or Marbury v. Madison yet, but you could perhaps look to that case for such a precedent to create a constitutional judiciary check on congressional legislative authority, and thus essentially your rights, ensuring that your rights are not infringed upon by lawmakers. Now, as to the executive, well, we all existed under a time with a top-end, bloated, heavy executive. I'm talking of the king, yes? We do not wish to create another bloated, top-end government, or else we would have been better to stick with monarchy without the bloodshed. To create monarchy under a new name of a republic, we should be very wary of extending too much authority to an executive, and thus the executive might be checked by the people, and equally the judiciary power. This is a fine clockwork, you understand. The government must not just check the people, but check itself and allow the government to check itself as well. This is a complicated clockwork. We won't get it right in this year of 77, but if we don't get it right this year, we'll get it right next year, and if not then, maybe in 250 years, maybe you'll get it right, Samantha. Fix it all for us, will you?
Mr. Wythe, did you have anything? I know your opinions of the role of the judiciary are ever growing.
In terms of the judiciary, it is my opinion that an opportunity for the judiciary to ensure that laws passed by the legislature are in fact in concordance with the words and terms of a constitution, in particular here in Virginia, I mean. This is essential. We see in our own history, back at the time of Coke, when he was writing his institutes, you remember Cook's Institutes, don't you, Mr. Jefferson?
Yes.
Cook's Institutes, written by Sir Edward Coke. And during his time, a case came before him known as Dr. Bonham's case, and he attempted at this time to institute what you might refer to as a review, a judicial review, for lack of better phrasing. Now, this was rejected by the higher courts of Great Britain and by the monarch at the time. However, we have instituted, in terms of making the laws themselves, an attempt to derive the greatest benefits from all three major forms of government in man's history. We have democracy represented in the House of Delegates, we have the aristocracy represented in the Virginia Senate, and we have the monarchy represented by way of the executive or the governor's office here. We are attempting here to take the good while dissuading the bad. You dissuade that bad, for lack of better phrasing, through these checks in power. And it is essential now, especially since the governor's office here in this year of 77, to take the phrasing from our friend Governor Henry, the governor's office is a dog without teeth. Mr. Jefferson did make a point a moment ago that we have all lived under a bloated executive, but it appears now that we have removed nearly all power from the executive office, and I am of the opinion, if I might be so bold, that we have removed too much and given too much to the legislature.
I thank you, Mr. Wythe. This next question, I believe, may be for you, Mr. Jefferson, at least in part, because Fanny wants to know, were women considered equal or chattel, and why weren't they included in the Declaration? I imagine that may reference a certain turn of phrase that you used within that document.
Thank you, Fanny. Considered chattel, movable property, nay, women, white women, it should be, say, free women. I shall go further and say free women are not considered chattel property. Although, so sometimes and I understand this question, what are women in our society? Do women have rights? And this is... I assure you, we would not be so kindly met at the dinner table were women not guaranteed rights in this country. A man and a woman may enjoy most of the same rights. The two rights you're probably looking at are the right to vote, the right of suffrage, and indeed the right to hold public office, as you do not see a female and will not see a female in the House of Burgesses or House of Delegates, nor sitting on this committee. Now, as to a particular phrase being used in the Declaration of Independence, I suspect you mean all men being created equal. When we say man in our time, in the age of the Enlightenment, we're taking that phrase, man, from philosophers of our time, philosophers in this age of enlightenment. And when we look to philosophers from whom I stole that phrase, I am an attorney, I get paid to steal, we can look at philosophers like Jean-Jacques Rousseau or Montesquieu or John Locke or even Descartes, and when they use the phrase man, usually they capitalize it first of all. Second of all, when they say man, they mean the collective body of mankind, which does indeed include the fairer sex, your sex, the female. So when I said all men are created equal, borrowed from more ancient philosophers, I was indeed also paying homage to their systems of philosophy, which was a more grandized system of understanding of man, not delegating one sex to being outside of those rights, but rather the inclusion of the collective body of mankind. Now, the Declaration of Independence is a philosophical document. It is not constitutionally binding. So these philosophies that we hold in the Declaration of Independence to be self-evident have yet to make the teeth of traction and action of law. That's the work now, to take the philosophy and place it into law. I thank you for your curiosity.
Well, gentlemen, I am afraid that we have let the time get away from us. We only have time for one last question, and I will read it. It is from Tina. She asks, since laws are essentially social contracts, will it be necessary to change laws as society changes? And will add on my own, what do you think happens next? Where do you proceed from here? What is that change that you will attempt to enact here with the Revision of Laws Committee that you now sit on?
I'm sorry, I have to do this apparently after every question. What is your name again?
It was for Tina, or from Tina.
Thank you. This is the question of your age, Tina. It will be the question of every age this government from here until ad infinitum when we end. Laws, I believe, should change over time. In fact, I wouldn't mind, Tina, this is fairly radical, but I would not mind seeing a natural sunset on every law ever passed. That is about 19 or 20 years. That after 19 or 20 years, the law automatically gets shoved into committee as a whole, where the committee then has the simple chance to up or down vote it, keeping it within lex scripta, or voting it away, or even shoving it over into some side committee, subcommittee, for revision, and then placing it back onto proper lex scripta, ensuring by this, mind you, that you need not be beholden, as I say, beholden to the laws of our fathers, that you can create your own laws. I also say it this way: man cannot wear the same clothes at 40 that he wore at 14. So should our laws change over time to reflect the progress of mankind. Who knows what you will create, Tina, that we could not fathom? If you were only and solely beholden to the laws that we create, if you could not alter your system of government from within, then the only means by which you could alter your government is through bloodshed, through another civil war. I don't wish that upon you. I know you do not as well. So what is your obligation now? It's to take the crown that you have inherited, stare directly at the face of the nation that you've also inherited, and ask yourself, how can I do better? You won't get it all right in 2021. Surprise, I know. But maybe you will take the lessons you've learned from this year and bring them into your next year. And like Janus with his two faces, both look back with reverence and understanding of the history, and equally look forward with hope. And maybe, if you do this, maybe we can outlast the Romans.
We acknowledge, Tina, that no man is perfect. Therefore, as I believe we made mention earlier, it is impossible to expect that we shall create perfect laws. It is impossible to expect that this Constitution of Virginia is perfect in and of itself. As a matter of fact, I criticized it just a moment ago, a year and a half, not even a year and a half, after its adoption. It is imperative, as Mr. Jefferson says, that the law change from time to time to better reflect the people for which it is used. It would not stand to reason, would it, if we were to be bound entirely by the laws of 1215. As a matter of fact, most of us couldn't even read the things. It is entirely necessary, Tina, and everyone who hears my voice here and now, that we not only allow the law to change, but we ourselves, as members of the Republic, take the responsibility to be in part of that change. Wise men do not cry for freedom. Wise men cry for liberty. What is the difference? Mr. J., you and I have had this conversation a number of times. Liberty is different from freedom in that freedom suggests a state of nature, a state without law, a state where one man is entitled to his full rights, meaning he can say what he wants and do what he wants so long as he can demand it. We do not live in a state of nature. We do not live in a state of freedom. We cry for liberty here in Virginia, which is an equal application under the law. Now, perhaps where you are, as we here in Virginia, you look around and you see the law ill-applied. You see it applied in a way that benefits some and ill benefits others. How is it that we can call this a place of liberty if we ourselves, members of the Republic, our brothers' keepers, our brothers and sisters' keepers, if we see them suffering as a result of an ill application of liberty and do nothing? Our virtues command us. We are commanded both by morality and by religion, if I might be so bold as well. When the lawyer approaches Christ our Lord and says to him, "What is the greatest of the commandments?" Christ replies, "To love the Lord your God with all your heart and all your mind and all your strength, and to love your neighbor as you love yourself." And he continues to say that all of the law and the prophets hang upon these two commandments. We are compelled by nature, and we are compelled by God here in this republic to take the crown that Mr. Jefferson has just made mention of a moment ago. We took it off of the head of the King of Great Britain, divided it equally amongst the freeholders here, and yet by our own loaves and fishes miracle, is it not true that that individual crown on each of those heads bears the same weight as the original? From this moment forward, we control the laws of this place. Those who have the franchise are responsible for those who live within the jurisdiction in their society. And so this is my call to you, to recall this when you look around where you live and see an ill application of liberty. Mr. Jefferson and I and Mr. Pendleton will do what we can here. But as Mr. Jefferson says, this will not be the end of it. The laws will continue to change by necessity. And so for that, my friends, my neighbors, my fellow citizens, my fellows in mankind, I say to you, from this day forward, it is important that we remember our individual place within the Republic. And in doing so, we say to ourselves that ancient phrase, e pluribus unum. You've seen it written, I know. Keep in mind, from the many, there is one.
This project was funded in part by a generous grant from the National Endowment for the Humanities.